said about your children being removed. He thought that your children should not be removed. You think, as you have stated to me numerous times, that you can just be involved in anything other than your life with your children coming home is going to be less than satisfactory to you.
Miss Johnson, you...
on and on about things that do not apply to the DSS.
Yes, it does. Constitutional rights? Are you saying that search and seizure, a constitutional right, does not apply to our children?
No search and seizure for the third time. There was no search and seizure of your home. You were drafting things from criminal cases that do not apply to child welfare cases.
Then where is our protection, ma'am, from our children being seized with no paperwork? Two police with guns and a strange woman came and took my children. I have no protection against that? They can just take our kids whenever they want? That's what due process is, Miss Johnson.
And the due process is when you went to court, the information was presented, even though you're saying that your attorney lied and the social worker lied, information was presented to the judge to say, is it needful for these children to be in the custody of the local DSS at this time?
They are supposed
to... was presented, and the judge said, yes, it is deemed necessary for the department to have custody at this time.
No, it was not, because what was presented were lies. Your kid...
I said that, Ms. Blevins. I just said that you feel that that is the situation.
No, that is not a feeling.
The judge did not feel that that is the situation.
Miss Johnson, that is not a feeling.
The information that was presented.
I can show you, Miss Johnson, I can show you the piece of paper that shows where my attorney had allowed consent for DSS custody, and that is a lie, because I never allowed that. And you know what? I told the judge that when she asked if I was okay with what was going on, and I said no.
Okay. And so after you said to the judge that you never consented for your children, the judge was aware. The judge still, because this was not based on consent, Ms. Blevins. This was based on the information and the conditions that were going on at the time the department became involved.
Based on perjury. Based on perjury, Ms. Johnson. Are you condoning perjury?
It was, okay. So you're saying that everything that DSS presented in court on that day was not true. Every single bit of information
yes, ma'am.
Had was not true.
Yes, ma'am. With the exception of that we love God, and yes, we're weird and strange. Did you know part of the allegations were that we exhibited weird and strange behaviors?
I cannot hear you. Your phone is breaking up.
Did you understand that part of our allegations was that we exhibited weird and strange behaviors? That we were obsessed with religion and God?
You told me about that, but that was not one of the reasons your children were removed. There are a lot of people that exhibit weird behaviors. That was not why your...
Then you tell me why my children were removed. Why were they removed? Because in the initial report, I'm telling you right now, in the initial report, she created allegations. Rita Miller, whatever her name is, I think it's a fake name. She created allegations.
The social worker, in terms of if the children were removed, the allegations that were reported to DSS at the time of the report were not made by Ms. Miller. They were called in by someone else or shared by someone else.
I'm telling you that what they presented to court were things that Ms. Miller made up and added to the initial report. Because by due process, that woman should have come and did your assessments with our family to find out if those initial reports were true or not. And that's not what she did. She unlawfully detained me several times using the police, the law enforcement, county and state, and she created more allegations. Perjury. She created perjury. And they took that into court. And that is how the Department of Social Services in this county has my children, based on lies.
Okay, and if the department has been awarded custody by the judge of your children based on lies, then it it becomes the responsibility of your attorney to prove that those lives existed and that your children should not be in the custody and that you are an appropriate mother who can properly care for your children should they be returned to your care.
So it doesn't matter that you can, so are you giving permission for this county to just seize my children against my constitutional rights?
I don't give permission for the county to do anything. I've told you from the beginning, and I will tell you again, the county, we draft the policies. The county in North Carolina, there's a state supervised county administered system. The department has presented information to the court. The court has said it is necessary for your children to be in the custody of the department. The judge has given permission for DSS to have custody. I cannot do that. That is
I'm not asking you to change the order. Ma'am, I'm not asking you to change what the judge says. I'm asking you to hold this department accountable to the state policies and procedures, which clearly outlines that a family has constitutional rights. It's in your policies and procedures, and that we have to preserve that and the safety of children. And you have neither, this county has neither did that for my children or did that for my family. And yes, children can be part of a seizure for constitutional law. There are Supreme Court rulings for that. You can't tell me that that's not.
Ms. Blevins, I am not going to attempt to argue constitutional law with you because that is not the thing that we're looking at. We're looking at the fact that your children are in DSS custody, that the judge has said that it's necessary at this time, and even though you feel that the department did not go about it in the right manner, the judge has said the children need to be in custody.
Do you realize that they committed perjury, and that's what made the judge order the way she did? Do you realize that?
No, I do not realize that. I realize that you were saying that, but I am not saying that is the situation. So,
and I'm willing to show you that they perjured. Are you willing to look at that evidence?
To you, it's that if you continue to say that the department has committed perjury, then again, your most effective recourse is to get with your attorney when she calls you back or when he calls you back.
He doesn't.
These are all of the things that I felt that the department misrepresented. I need you to prove that all of these things were lies. That is not anything.
Ms. Johnson, I'm willing to give you the proof. I'm willing to give you the proof so that you hold this county accountable to what you're asking them in their policies and procedures. I need someone to ask them to follow their policies and procedures because they are here in Guilford County seizing at an average of 21 children per month so they can pay their light bill and destroying families. An average of 21 children.
Your children in care for a month so they can pay their light bill?
Yes, ma'am.
Miss Blevins, did you even listen to how that sounds?
It's, you know what? To the person who doesn't have their children just ripped out of their arms? Have you ever had a child ripped out of your arms? Threatened to go to jail?
No, I have not.
Yeah, and until you realize the depth of the corruption in this particular county, you won't understand.
Okay.
I can show you proof of perjury.
To move this along, what do you have that you feel would be of benefit to prove that the department perjured themselves when they presented information to the court?
There are two things on paper if I cannot get court records. Court records would show you a slew of things. The court records would actually even show you the caseworker who sees my children perjuring in court. But there's the caseworker that I have now, she has written in her disposition record for court perjury. Like one of them says that I signed the case plan. And I have copies of those, and I'm willing to share with anybody who will look at them. But I'm hoping that you guys would realize I can pick apart your entire policy and guideline and tell you where everything has gone wrong with what they have done to my family.
Okay, and that is definitely something that you believe and you feel very, very strongly about. So you're saying that in the court petition contains lots of perjuries as well as the deposition. The disposition. The
disposition court report that Tyree Hooker prepared and the non-secure custody papers are all full of flaws, are all full of perjury. The testimony that Sorry Rita Miller testified during adjudication is full of perjury. They actually added things on to the allegations in adjudication.
Okay. Well, again, I will ask the department for that information, and I suggest that you get with your attorney about the things.
Ma'am, you don't understand that I have no attorney. If he is not willing to communicate with me, this is a tactic of DSS. They are not.
Does not work for DSS, Miss Blevins.
They're friends. They go biking. They go biking. He goes biking with the guardian ad litem attorney. And they're all friends with the judge on Facebook.
It's awarded by the court, appointed by the court also. DSS does not have any dealings with either the GAL attorney or your attorney. They have been appointed by the court. Do not say that there's collusion occurring between them and DSS. Because
right.
DSS has no bearing on them.
Well, if they have no bearing, why are they giving my records to the lawyer when they knowingly know that he's not communicating with me? I've sent emails to Tyree Hooker telling them.
If your attorney has asked for the process called discovery and has requested the records to review.
No, I'm not going through my attorney for those records. I'm going by open records law in North Carolina. Open records law. I have a right to the open records of the Department of Social Services.
This is a DSS case, ma'am. This is a confidential case. No one just gets to look at those.
I get to get those records. I get to look at those records according to state statutes. I do.
I get to look at those records, Ms. Blevins.
Yes, I do.
The DSS case. You do not get
Yes, I do. It is in the state statutes.
Look at those, and it was your attorney sharing those, but you cannot just go to DSS and ask for the case records.
Yes, I can. It's in the state statutes.
Okay.
There are certain people allowed to look at those records, and the parents are one of them.
I'm not going to argue this with you because I know what the policies are that pertain to child welfare records.
Well, if you know those, you should know that you're not allowed to perjure as a caseworker either.
I know that perjury should not be permitted in any case, and a social worker has an ethical responsibility not to lie. Now, the question is, if the social worker perjured herself, that the judge can determine, or if you feel that she did it. You feeling that she did and her actually doing it are two separate things.
No, because I have proof of her doing it. You know.
And that's what I'm saying. If you have proof of her doing, please share that with your attorney so he can call her on that.
My attorney will not call her on that. I'm trying to tell you that my attorney will do nothing. He's sitting on his hands, and I have to look for somebody to make him accountable, like I have to look to find somebody to make my caseworker accountable.
Okay, well then you can call the state bar if you feel that your attorney is not giving you adequate representation, and I will speak with the department about what you feel it is whereby the social worker perjured herself. Can you tell me 3 things that she perjured herself upon so I can follow up with the department?
Yes, the court disposition record is full of perjury.
No, I said 3 things.
That's one of them. Court disposition record. The non-secure custody form that they filled out. They filled out that I granted...
I'm talking about the specific things within that. Do not just give me a blanket statement. What are the specific things in the court disposition that you feel are perjury?
I can send you an email if you'd like.
No,
I don't have the court disposition here in front of...
Confidential case.
Ma'am.
Confidential case, and I cannot have...
Then I can call you when I get to my court disposition paper, because I have it all marked up with the perjury.
Do what?
I'm not at my house right now with my court disposition with the records that I have where she committed perjury. I just know one of them off the top of my head, and I'm having a bad day. One of them off the top of my head is that she wrote that I signed the case plan in there, and I did not sign the case plan. That's one of them.
Okay. Well, and one of the things was that, and let me just say one thing that I don't need to have a discussion on. So you're saying that she wrote to sign the case plan. We may have a situation where the social worker misspoke or she misstated and she did not intend to lie, because perjury is when you knowingly lie, and it may be that she thought that you signed it when you did not.
Ma'am.
So thank you for that.
Ma'am. No. I don't think so. You are not excusing her for perjury, thinking that maybe she might have made a mistake. Okay? Because I have... No. Listen to me. I have plenty of emails telling them I'm not signing the case plan. You can't make excuses for her.
What I have to say is I don't know what happened. I don't know what her intent was. You were reporting information to me, and so the same way that you want me to believe you and give you the benefit of the doubt is the same thing that I have to believe for Ms.
No, I want her to have proof. I want her to have proof for you, because I can give you my proof. I have lots of emails stating to her that I will not sign the case plan because I did not get to give my input.
And he told me that. So my thing with that is my question will be to management. Why did you say, if she in fact did say, that you signed the case plan when you had indicated on numerous occasions that you were not going to sign the case plan? So was that something where she misspoke, or did she just not remember, or what is the situation?
No, you don't get that. You do not get that. You know what? You do not get to excuse perjury.
I am not trying to excuse perjury, Ms. Blevins. I am telling you, I do not know, number one, what the social worker said, because I don't have any documents saying this is what she said. I do not know what her intent was. I am not trying to excuse her if she lied. I'm telling you, I have no information other than what you have reported to me.
I'm willing to give you the information.
Of trying to excuse her behavior.
I'm willing to give you the information. I'm willing to give you all the proof that you need.
And I am willing to get that from the department as well to see what is in there, because if it's a deposition, then they cannot alter the deposition. Disposition, I will have that.
See, and this is why the judge is making decisions based on perjury, and you can't say as the Department of Social Services, well, the judge said this. No, the Department of Social Services in this county has an obligation to be ethical and professional, to protect constitutional rights.
So we don't need to argue that point anymore. I agree with you wholeheartedly, and that is just what I stated to you 5 minutes ago.
But also, ma'am, in the same policies and procedures that this department is supposed to abide by through the state, it does state about the upholding and protection of constitutional rights. That is part of it. Those rights are there to protect our families from the abuse of authority. And that's what my family is suffering the abuse of authority under lies.
Okay.
So you can't say that my children are something that can't be seized, because, ma'am, like I said, you were not there when they were seized. They were ripped from my arms and put in the car of a stranger under threat of going to jail. That's seizure.
You're right. I was not there. I do not know what happened. You can call it what it is, but I do know that there are certain steps and there are certain laws that allow CPS to become involved with a family when they think it is prudent to do so, and the department did. And what I'm telling you is, I maybe
they did not
how it happened of what was.
They did not make that decision by due process.
Remove your children. They went to court. They told the judge why they felt it necessary.
Based on lies.
To remove the children.
Based on lies.
Yes, the children need to be there. You're saying there are lies. I don't know. I need to look at the information.
Okay, please also
from the department.
Also look at the way in which they were seized.
I cannot look at the way in which they were seized because the department is not going to have a minute-by-minute account.
Yes, they are actually. You can talk to Sarita Miller. Yes, you can. You can talk to Sarita Miller, who testified in court under penalty of perjury. You can speak to her because she's an employee of this county Department of Social Services, and you can find out the way in which they were seized. You can find out that she didn't do the assessments and she did not take the policies and procedures that you guys have created and implement them in the seizure.
Find out if you believe that she did not do that. That is your estimation.
That's not my estimation.
That is your perception.
That's not my perception either.
Whether she did that or not will be up to the department to determine, because the department is also responsible for making sure that their employees follow the guidelines that we have in place.
Even in seizure, ma'am, they were not, those policies and procedures were not followed in the seizure, and if she had actually followed due process, then she would have done the right thing and DSS would not be involved. Because I've looked at those.
Not necessarily.
Yes.
So, but again, we've already discussed that and you disagree with me, so we are not having.
Well, then I'm going to encourage you to ask. Then I'm going to encourage you to ask the procedure that Sarita.
Please do not tell me how to do my job. I am very much aware of what it is that I need to do in order to look into this like I did it before, but I will go back again a second time. So I do not need your guidance in what it is that I'm supposed to do in the review of this matter.
Well, you're sitting here saying that you don't have proof, but I'm asking you to go get proof. Ask Sarita Miller what assessments she used, and I guarantee you she didn't use any.
Okay. Well, I think I have what your concerns are. I am not going to go around the bush again with you regarding the issues. I will definitely set up a time to speak with Mr. Lee, Ms. Miller. I will ask that she is present as well as the supervisor regarding the CPS assessment, what the concerns are, and I will also ask them to please send me the court report that was presented to the court as well as the information from the court petition and the disposition.
Thank you.
Thank you. Have a good day, Ms. Blevins.